Today we're visiting Archies Fine Coffee. This coffee shop offers more than just your usual lattes and cocktails. They also serve cannabis-infused coffees, mocktails, and other products, creating a unique twist on the classic cafe experience. Archies captures the authentic vibe of an Amsterdam coffee shop right in the heart of the city. Cannabis-infused coffee.
Yeah,
in Texas.
Brave new world.
How do we get here?
Seems like it's a pretty circuitous route, and it isn't exactly clear what here is.
I mean, I guess we should probably make sure that everyone's aware that this does not constitute legal advice. This is more of a comment on the state of the law, the legal gray zones and areas, and how we think it's going to proceed from there.
Exactly.
But I guess starting from the beginning, Farm Bill, federal Farm Bill?
I think we got to go back from there. I mean, up until 2014, somewhere in that neighborhood, Texas was just a pure prohibition state.
Right.
As other states in the union were starting to tease out the idea of a full-bore recreational cannabis program for, that and blended with medical in some way.
Right.
Texas was basically just no, under no circumstance.
Right.
There had been a case maybe in the late 90s, early 2000s, where a man who's dying of AIDS successfully won a not guilty verdict based upon necessity of using marijuana as a therapeutic tool to help him die. That was about the only positive news story in the Texas marijuana landscape for a long time. California has been on this crusade for the medical treatment of cannabis, the medical legalization for a long time, over 20 years. Some of that rhetoric, some of that dialogue was beginning to make its way into the Texas legislature. So we get the Compassionate Use Act.
Right.
I think that's probably the beginning of the story to get to a place where you can have a brick and mortar establishment in Texas selling a cannabis product.
As a starting point for legal use in Texas, I guess where we are now with infused products, cannabis derived, you would agree though that almost universally that's going to track back towards the federal Farm Bill.
Right, but you'll notice that we have some carryovers from compassionate use, like the 0.3% THC by dry weight standard that's being bandied about in all of these laws.
Was the 0.3% dry weight standard informed by the Compassionate Use Act?
No, but clearly whoever's writing all these bills has that concept entrenched in their head, and part of why this is such a gray area and it's so difficult is because that standard is almost meaningless.
Right.
And yet we've been carrying that baggage around since compassionate use. I mean, just to be clear, it's not like Texas one day woke up and said, we're going to legalize cannabis for medical use. They legalized it for, a handful of very severe conditions. For adult use only. Epilepsy, I think.
That's right, epilepsy.
Probably glaucoma.
And then it was expanded to PTSD issues in certain cases, I believe.
And that's an ongoing expansion.
Right.
But there were only maybe one or two people who could have passed muster for licensure to be able to provide under that, and then physicians had to get on board. And so it wasn't widely used.
Well, I mean, there's still only a handful or less production facilities in Texas that operate under the Compassionate Use Act.
Exactly.
And I mean, and they're being shut down because of the prevalence of legal hemp.
That's right. They created such a massive amount of red tape that there's no real incentive for people to have to go through it in order to be a participant. And what you'd often see is people who had sort of resorted to self-help. They were firmly of the belief that marijuana in some form or fashion would help whatever their condition was. They were self-medicating with that choice under the radar, potentially in the black market. Then they would get in trouble and they would think to themselves, well, but I had this necessary reason for me to consume it. And so then they try to get onto the program on the back end and having disastrous results from that. So I mean, it's still a law in Texas, but it's pretty much a failed structure. But I mean, from that, we see the beginning, the genesis of all of the things that were to come, even though some of those weren't anything to do with the Texas lab.
Right. We have the Texas Monthly article coming out a couple months ago, essentially finding that we're in gross violation of that statute, right?
The Compassionate Use Act is just sort of the backstory.
Right.
Right.
Yeah.
The federal Farm Bill comes in, and from the federal government level comes in and says, we're going to carve out this little subsection away from the Controlled Substances Act's general prohibition on cannabinoids. We're going to say that naturally derived cannabinoids from a hemp plant that don't exceed those concentrations are now exempt from the penalties of the Controlled Substances Act. Basically, it was the federal government coming in and putting their foot down and saying, claim preclusion.
Tell me what the difference is between a hemp plant and a marijuana plant.
There ain't none. There's no difference between those two plants. They're the exact same. DNA is the same. Genus and species are the same. It's all marijuana.
Smell, taste, presumably.
Everything about it would be the same.
The only issue that we're really talking about is essentially THC, THCA, the precursor acid, or CBD, CBDA contained in the plant, right?
Exactly. I mean, it's like, a Cherokee purple tomato versus like your normal slicer tomato at the grocery store.
Right.
They're the same plant.
Okay, so we have the federal farm bill that's passed, legalizing and carving out this exception for low THC marijuana.
Right, and with it, essentially claiming the field away from the states.
Right.
So behind the scenes nationally, we also have to talk about the fact that this is a real messy patchwork, where on the one hand, the federal government wants to say, us first. The Controlled Substances Act is the benchmark that all other states should be rallying behind, and federal law will ultimately dictate whether you go to prison or not.
Right.
And on the other hand, this patchwork of different laws and regulations in all 50 states, some places where recreational is legal, some places where there's total prohibition.
I mean, and even more telling, each state having a different harvesting period, which is ultimately how you're going to determine whether your hemp is in compliance with the federal bill or not.
The feds say this is how it's going to roll, and that would include whatever administrative decisions come down the pike, some of which are still not fully implemented, along the lines of, this is how you test, this is whether you test before harvest, after harvest, both, how you test, how commerce will be regulated between the states regarding this, controls on prohibiting states from blocking travel and commerce to legal states, all that kind of issue.
And Indian reservations, I guess.
Indian reservations, all of that. Then sort of an invitation. Hey, if you don't like what we're forcing you, state governments, to do, then we will let you take the field back from our supremacy analysis. It becomes your game. But you can't go outside these parameters.
Right.
You have to be able to honor the basic grant under the Farm Bill for the interstate commerce of hemp.
I mean, I guess we would agree then that within those parameters, legally under the federal farm bill, we could end up with hemp that is extremely low THC, THCA content, but also essentially if it's tested early in the cycle and allowed to ripen before harvesting, theoretically legal with massively high quantities of THC, THCA, CBD contained in the plant legally.
Well, you've hit the problem.
Right.
I mean, and this is where the debate will continue to rage, and where what's going on administratively in the federal government is so important to the discussion. When you harvest and when you test are the major questions, and how the state government chooses to implement those controls is very significant. Because what the feds are saying is, this is how we would do it. And this is how it's going to be done in the absence of your legislature coming in and creating a compliant set of rules that work for your state.
Right.
And Texas took up that invitation and passed the hemp bill, which legalized that subset of marijuana plants with that 0.3% threshold. And that's the same as how the feds treat it.
The difference, I guess, being that Texas requires harvesting 15 days after testing, so very short window, right?
Right. Under the Texas regime, you're not going to get these high octane, super potent strains of marijuana.
Right. I mean, think of it like fruit you buy at the grocery store, right? You buy a banana, it's green. 3 days later, it's rotten. It's like it will mature over time, and if you test at a certain point, it might have almost no cannabinoids in the plant. Then under state law, you're allowed to withhold harvesting it for some time. So Texas, you have 15 days, I believe, I think is the period. But I mean, other places, North Carolina, Hawaii, are much longer, 50, 60 days, somewhere in that range.
And not just when you test, but how you test.
Right.
Which is almost as important, because what we're really talking about, we talk about these legal products, the majority of what's flowing through Texas that's being categorized as an intoxicating but legal THC varietal, whether it be flower or it be some kind of a tincture or an extract. The way that they're contending that is,
it was produced legally in
that
another
material
state.
was produced as hemp, or a hemp-derived product, legally and pursuant to federal law.
And state law.
And in accordance with that state's cultivation and testing procedures. But the reality is, Delta-9 THC does not occur just on the marijuana plant,
right,
in very high concentrations. I mean, it does in small amounts. What occurs is that THCA, the
precursor
tetrahydrocannabinolic acid. And it's a precursor. So decarboxylation, lighting it on fire, gets you the Delta 9 that's the intoxicant.
I mean, I guess theoretically you still have some, some transition of that product just, from regular oxidation, being out in sunlight, it being held in your hand, but that's probably a pretty minuscule amount. I don't know. That's an entirely different question. If you and I are representing somebody accused of possession of marijuana, if you have that product sitting in an evidence room at a high temperature, 80, 90 degrees for a 2-year period, what's the effect? What's the degradation of that THCA into actual THC that wasn't contained in the plant naturally at the time of the seizure?
We know that some of the THCA will naturally decarboxylate for all those variables you're talking about. And we also know that some amount of Delta 9 THC may in fact be excreted by the plant just out of the gate, not as the acid form.
But that's a pretty minuscule
amount. Yeah, exactly. The bigger problem is that when you test for it, wherever you're testing for it, whether that's at the end of a criminal case where they're running it in a crime lab, or you're testing for it pre-harvest in the field or in the grow room, the method of testing will determine your answer in very skewed ways. Because to decarboxylate is to light it on fire. Well, the most common way to test any drug is gas chromatography. And gas chromatography requires combustion. So you're going to have to smoke that flower in order to get the vapor that you can run through the coil and test. And that's going to change the chemical profile of what you're testing.
But also, a lot of these laws account for are designed at least, or theoretically designed to account for the total THC concentration post, testing through mass spectrometry.
Texas's problem is that we can't seem to regulate other states' testing methodologies as they get imported. So the way that the DPS regime for Texas hemp growers operates, and they can spot what they call hot hemp, and they can order that destroyed, they can find that person, there's minimal criminal exposure for those issues. While we can police the state production for hot hemp, if another state has a different testing regimen that complies with their laws and that is otherwise valid under the Farm Bill, in other words, it doesn't violate federal law, it doesn't violate, say, Oregon, North Carolina, whatever. We're not allowed to go and second guess their regulatory process for testing. So what would be hot hemp in Texas, legal hemp in, say, Oregon?
We would agree then that really the main effect of Texas's hemp laws is to limit production in state.
Intended or unintended, that has been the effect. Right? The probably every product that was generated to stock the shelves at this shop, I would be shocked if it had Texas origin, because that's just low probability given the way our structures in Texas are set up versus these other places. Probably not a place like this, but of course, from a consumer protection standpoint, there's a lot of counterfeit THC products that float around on the streets that are being sold at gas stations and bodegas, things like that.
How much of that do you think is holdover from what, Delta 8 and the synthetics that we saw 5-6 years ago?
I'm sure a ton of it, because the regulators can't keep up with the way that this industry is exploding. So in the beginning, the idea of it not being a specifically enumerated prohibited substance under the Texas Controlled Substances Act emboldened a lot of people to say, well, fine, we'll just do Delta 8, we'll just do Delta, whatever. But the problem is, while those cannabinoids are on the plant, most of them aren't on the plant in enough quantity to ever get realistically out of actual plant material, so they're synthetically produced out of CBD.
What, sprayed on after the fact?
Well, I mean, however they get it,
So that's the landscape up until very recently, where we have the DEA saying, nope, hold on, THCA, we're going to classify that as a controlled substance.
What they basically have come out and said in a letter, right? And let's delineate this, because admin law is a giant mess, and it's obviously neither of our area of expertise, but employees of the DEA have issued a written statement saying that they interpret THCA to be part of the Controlled Substances Act.
Even though it's
prohibition.
Even though it's essentially, non-functioning without being converted into THC. It's inert.
Well, and this is the question about whether it's the whole cannabis profile, how many cannabinoids total, or whether it's strictly a function of the amount of Delta 9 THC in the plant, and about at what point in the process are we
testing? Right.
What you end up with is as long as you maintain the position that whole cannabinoid totals for the plant are a matter of state interpretation based upon their law. The state gets to dictate when the harvest, when the testing is done in the harvesting process and the methodology done.
Right.
There would be essentially no evidentiary basis to demonstrate that the grower, the harvester, the manufacturer, the distributor is in violation of the law, because at those given moments of time, they're compliant, even if they may not be compliant in the finished product.
I mean, obviously there's massive evidentiary problems here, but theoretically you'd have to do something like with alcohol, a retrograde extrapolation to show that the content of the drug at this time, when you rewind the clock, would have been outside the scope of that particular state law, right, that it came from.
If we were really gung-ho about going back to prohibition, it'd just be a lot easier to say, never mind, we're going to just criminalize it all.
Yeah.
This is a valid debate. Okay, so the states where this is happening the most are using liquid chromatography to do their testing, wherever in the harvesting process that's being.
Because that'll, THCA, THC, exactly, you can identify them separately, independently.
No fire, no smoke, no decarboxylation.
Right.
So the THCA stays THCA, Delta 9 stays Delta 9. What the DEA letter assumes is that the only way to get a valid total cannabinoid profile for the particular plant is to do a decarboxylating testing procedure.
Yeah.
In other words, if you don't burn it, you're not doing it the way DEA wants you to.
I mean, to be fair, if their concern is people smoking it, I don't know that that's totally out of bounds.
Sure, from the perspective of being
a cannabis user, right.
The DEA is in the business of criminalizing drugs.
Yeah.
I mean, they have other functions, obviously, and they work with Health and Human Services to decide what's scheduled and what isn't, and whether that should be revisited. But if you look at the culture of what the DEA has done since, the 60s, it's there to make sure people don't use drugs. And so they look at this situation and they go, we were really thinking more about like essential bathroom oils and facial creams that have CBD in it that's derived from hemp, and we were really looking more at how to feed livestock with hay bales made out of hemp. We were not really all that gung-ho to turn this into just a back door to legalization. So whether that's a loophole or it's not, I think is a debatable point, but it's definitely the legal landscape.
If they were going to unwind it, is it even possible at this point?
Well, sure. They could just come back and say, never mind, it's going to be Schedule 1 and repeal the Farm Bill.
Can they? Following the changes to the Chevron? I mean, I don't know. It's the entire thing's a mess, right?
The Congress can repeal that.
Sure.
Repeal that law.
Directly they could. Do we think that it's going that direction?
No, in fact, right now, administratively, it looks like it might be heading in a more positive direction overall, even though in the short term, there are going to be big problems for regulators and for people that are in the business legitimately. There's been a disclosure that Health and Human Services, who's sort of the starting point for the administrative process, has gone through, done new research, and is making recommendations that it be removed from Schedule 1 and put on Schedule 3.
Right.
Now, that's still controlled, and those controls are still going to be onerous. And it's not like you're going to be able to go plant a forest of marijuana plants in your backyard. But it would,
at least not in Texas.
It would improve our ability to study cannabis. It would improve our ability to have clinical and medical trials with it, to test some of the claims about its medical efficacy. And it might make the recreational consumer market a little bit safer, both for the sellers and for the consumers. So we're all a little optimistic that that change is coming, but we don't know when it will come, or even if the DEA will fully accept the HHS recommendation. Right? And that largely depends, I think, on who occupies the Attorney General's office. Back in 2016, old Jefferson Beauregard was testifying before Congress saying nice people don't smoke marijuana.
Right.
That wasn't that long ago.
And now we're having findings that look, too many of the wrong type of people are being arrested for this offense.
That's right. And Biden's done great things to pardon and give clemency to people who were serving sentences for possessory marijuana crimes. There's a lot of positive change on the horizon, but none of that will directly impact the day in and day out aspect of, is this a retail product that you can buy in a brick and mortar coffee shop, or is this something that it remains black market?
That's more of a 10,000 foot view of the federal scene. In Texas, this is coming back up for debate.
You can see, I think, in the media that there's backlash already to what has already transpired. I mean, the New York Times last week had an article about the dangers of cannabis use, especially at high levels of intoxication.
Right.
And it makes a big to-do about these seemingly rare occurrences where people get horrifically nauseous because they've consumed so much, or people that have had psychotic episodes from it. I mean, it's a drug. It's dangerous. Everything that you put in your body is potentially dangerous.
Yeah, I mean, I think the Texas Monthly article that came out, I think, we were talking about briefly earlier, at the point that they're doing the testing, and it's unclear what type of testing they were doing, right? But they're finding a total THC concentrations in like the 40-50% or something silly. And then
we know that's about the testing.
Exactly.
If you tested that through liquid chromatography, it'd probably be less than 0.3% delta-9 by dry weight.
Right.
That's the way it's supposed to be.
Right. But then, the result is you have Texas senators being appalled, saying, look, the purpose of the hemp bill was to provide another cash crop for Texas growers, not to legalize marijuana, which they, I think that they're scared that they've de facto done, right?
Well, I think it's a clutching at pearls.
Yeah.
I mean, either they are truly that breathtakingly ignorant of the science of what they were trying to regulate that they accidentally legalized it. Or,
I mean, that's never happened before, right?
Well, there is that. Or everyone knew that this was going to be the tantamount effect. And if you think about sort of like the end of alcohol prohibition, what did you end up seeing? There was a stratification based upon mostly class, socioeconomic status, racial divides, things along those lines, where the people in the most privileged positions of society were able to continue drinking their alcohol.
Right,
Without
no problem
any
at all.
interruption at all. But God forbid you were poor, a minority, having to live in a way that was not the peak of societal existence, you could face serious prison time.
Or health problems, which I guess is the same issue here, right? You hear the stories of the bathtub gin, people going blind. And
wood alcohol.
Exactly. And so, we're really just talking about a similar situation here where, it should probably be regulated and more closely monitored so it's done safely. There's not contraband or I should say counterfeit products being put on the market that have unsafe components added to them.
If I gave a 7-year-old a $20 bill and told them to go to any corner store in the state of Texas right now, they could buy a cannabis product and walk out of the store with it.
Right, because there's no age limit on it.
No age limit, no nothing.
Right.
And as much as I would say I'm probably about the most no government libertarian you've ever met, even I think that we ought to at least impose an age limit.
Just roll that back a little bit.
I mean, I'm sure that places that are more reputable, just out of common sense, are going to say, "I'm not selling it to you. Where's your dad?"
But it's past your bedtime, kid.
That's right. But there's nothing stopping an unscrupulous retailer from doing that.
Right.
And those kinds of things would be more common sense regulation. It speaks to just why prohibition's always a bad idea. All the behavior still goes on, but it goes on behind closed doors without any oversight, no responsibility.
It empowers the criminal element.
No way to even sue for recourse practically in a lot of these situations. What are you supposed to do? Track down the guy that made the counterfeit vape pen that gave you some kind of popcorn lung disease and sue them for false advertising? I mean, good luck.
No recourse. I mean, and then it empowers the criminal elements of society, right?
That's right.
How much marijuana do you think we see crossing the border from Mexico into Texas?
Not as much anymore.
Right.
I mean, I would say that's probably shrunk to insignificance.
Right. I mean, but as a direct relation, in correlation to the legalization, or at least decriminalization of different aspects of marijuana, hemp across the country, right?
Exactly. I mean, there's still a huge flow of illegal marijuana that, they're not even trying to abide by this regulatory structure. It's just they're growing it in a legal state. They have a glut of excess product. They truck it to illegal states and double their money.
Yeah.
And that happens all the time, but that's completely cut the cartel in Mexico out of the game, unless the cartel's playing that game here. None stops them from buying real estate in California. The cartel's switching to harder drugs, manufacturing methamphetamine and fentanyl.
Hopefully on the horizon, we can have some more clarity on this topic. I guess right now it's just kind of this giant mess, right?
What I hope is that the legislature will have a debate about it and finally say, let's quit monkeying around with this idea of we're going to criminalize some things about this plant, but not all the things about this plant, and just legalize it.
Yeah, that makes sense.
That would be the ideal. But will they do that? No. I think the Texas Monthly article was written to create fodder for a prohibitionist, reactionary approach in the legislature, and that's what we're going to have to be fighting against. But the article I think it takes a basic truth which is that the way that hemp is defined in the code, this THCA issue is just a part of it, and it's no one's fault but theirs that they failed to take this into consideration, and they're portraying it as though the law has allowed a runaway of basically criminal marijuana to be saturated on the streets.
I mean, it's a failure to understand the legal framework of the situation, right? Because as we talked about previously, it's not just the total THC, THCA, the total cannabinoids in the plant, right? It is relevant to which state it came from, the harvesting procedures and testing procedures at the time limit in that state. Assuming that that's all legal, then even though it might violate Texas law, if it was produced in that manner here, the actual end product is probably legal.
Well, right. I mean, if it meets our criteria, or our criteria can't be applied to it,
right,
then it's legal.
Yeah.
Keeping in mind, right, that you have multiple layers of potential danger. State officials could just try to tweak their administrative regulations so that they can go after you for that.
But doesn't that just run afoul of the Commerce Clause? Isn't that the road we're going down, right? Another state produces legal hemp in their state that is higher than Texas in quantity of THC. It's brought to Texas legally under the Commerce Clause. Actually, I believe the Farm Bill actually prohibits the interference of that transportation, that sale.
Right. It's almost more of a supremacy clause issue, because the feds said we're seizing this field from the states. It's now our province. We'll give it back to you, but you have to impose regulations that satisfy our basic expectations that you will facilitate commerce with states that have legalized it, that have chosen to implement a hemp bill regime themselves. And but how everyone defines hemp is how everyone defines hemp. The DEA has one definition for that total cannabinoid profile. It obviously expects the post-harvest decarboxylated testing, which would make almost everything that could be turned into Delta-9 in the plant become Delta-9 when it's tested. And they're going to say that's how we know it's hot.
Right.
Even though it wouldn't be hot if you ran it through liquid chromatography, even though it wouldn't be hot if you tested it a month earlier in the harvest process.
Right.
So whether they win that out or not, it's going to be a question of administrative law. It's going to be a question of how those decisions of the DEA and the HHS are interpreted by the federal courts, and ultimately whether cannabis gets descheduled or rescheduled. And those are all big question marks for the future. A lot of this stuff obviously impacts people who are wholesalers, cultivators and producers, brick and mortar establishments that are selling it. They're going to have their own set of headaches, and most of what we talked about is in their province. The bottom line is we don't criminalize behavior unless you have a guilty mind, right?
Theoretically.
Well, at least that's what they preach. Maybe in practice we know it doesn't go that way. But I mean, drug possession is a specific intent crime.
Right.
You got to know what you're possessing. If we find someone who's very naive to the world and hand them a bag of marijuana, but they think they're borrowing some oregano for their pizza, they can't be held criminally responsible for that. Now, in points in the past, they'd be like, come on.
Right.
Like, you obviously know, everyone knows marijuana is illegal.
Well, I mean, that brings up an interesting point, right? Police search is based on the smell of marijuana. Are you aware of any study, anything that points to the ability to differentiate between high THC marijuana and low THC marijuana or hemp based off smell?
No, in fact, I think no one who knows anything about it would say that there's a difference.
Yeah.
I mean, obviously, there is variability between plants, and sort of phenotypes might smell a little bit more dank, citrusy, or dank, whatever words you want to use for it. It all functionally smells the same, and that's botanically driven, and genetically there's not any difference that would.
To be clear, we're also talking about the smell originating from the plant, the burning of plant. We could have low THC concentrate, right? And in a substrate in a vape that's legal under Texas law.
Assuming that we're talking about something that meets those threshold conditions for concentration, we're talking 0.3% that's naturally derived. And I think where the DEA probably has its best arguments in the grander scheme, and where that guidance might be most helpful to state law enforcement, is if you have to synthetically manufacture it, there's a question about that. Now, can you prove synthetic manufacture? Good luck. I mean, that'd be. I don't think we have the equipment to do that.
Yeah.
Unless you know that there's some industrial solvent or something that's a residual byproduct that only would exist.
Some tracer that you can follow back to that synthetic process.
Right.
But yeah, I guess I bring that up as a counterpoint to the smell issue, because you've seen it before in cases. An officer says, I smelled a vape, I smelled a marijuana vape. And they're not actually smelling the THC there, they're smelling what the substance the THC has been introduced into. As far as the probable cause argument to search, to stop people on this basis, with the introduction of low THC marijuana, low THC legal, essentially concentrates, right? Where do we think the probable cause argument exists?
As it stands now, there hasn't been explicit guidance from the Texas Court of Criminal Appeals, which is the high court for criminal law.
We've got a couple of court decisions here and there that say that it's no longer probable cause to stop or search in a traffic violation.
Well, a lot of the cases haven't passed on it. There are a couple that have said it in footnotes or in dicta, so not necessarily controlling precedent, that have acknowledged that that argument for it to be a continuing basis for probable cause seems to have lost its footing.
Right.
How do you? It'd be like saying I smell cigarette smoke, so I need to search your car.
Yeah.
There was a case out of San Antonio, though, that's a little bit more difficult to parse, and that basically says that the odor of marijuana could still be taken into consideration as part of what
the totality of the
circumstances. Yeah.
Right.
Which is one of those phrases that's so meaningless that if you see it reiterated enough in a court case, that the toilet bowl is flushing for the defendant.
Right. Because what are you pointing to at that point? You have an odor that you're saying is consistent with criminal behavior. But aside from that, what are you pointing to? Time of day? Is it dark outside? Is it a bad part of town?
When I read it, I just keep hearing Jeff Sessions' voice going, "Nice people don't smoke marijuana."
Yeah.
Thinking that that would be really the only tie-in. We've run into this problem before. The courts have said for a long time that activity that is equally as consistent with innocent behavior could nevertheless form suspicion or probable cause.
And that's such a low burden that a lot of times it's hard to overcome that.
Well, it's a ridiculous opposition, and it shouldn't be the law, and the courts ought to be ashamed that that's what the position they've taken. But that's where we sit. What that means is that whether something was reasonable for a policeman to do depends on who the judge on the bench is, and not any objective standard, despite the claim that it's objective. So we're going to be struggling with this for a long time, but we at least do have a better argument now that it's not going to be alone a basis to search. And if you want to know the truth, probably, why has Texas got such a backwards, messed up, nonsensical regulatory structure for this process? Because they don't want to let go of the chance that they'd be able to find some major haul of drugs or all the stolen money from the bank robbery just because they smelled a joint out the window of a car.
Yeah.
Police do not want to let go of that tool because it's the skeleton key that gets around the Fourth Amendment. I think they know it, and that's why police unions lobby against it.
I think they frequently admit it, right? You talk to police officers and it's an open secret. They're saying the quiet part out loud. Don't take this away from us.
It's a systemic problem because ultimately it lets them avoid legitimate criticisms of racial profiling. It lets them avoid legitimate criticisms of acting on a hunch. It lets them avoid all of their preliminary bad behavior as long as just one of the people they stop that night has the odor of marijuana coming out of there.
And to be clear, that's the odor of marijuana. Don't you love the cases where there's the odor of marijuana, but there's no actual marijuana found?
Oh yeah, plenty of those.
Plenty of those. Clearly there was something nefarious happening, and they got rid of all the evidence except for the other, instruments of criminality that is the basis for the real crime.
There were a couple of dog sniff cases on the Supreme Court docket maybe 5-6 years ago. One of them was Florida versus Hardenase, which is about dog sniff searches on the curtilage of a person's home. There was another one, and I'm blanking on the name of it, but the dog alerted for marijuana.
Setting aside the other issues with dog sniff cases.
Oh yeah, tons, right? So we know that the Supreme Court says a dog sniff can form probable cause. That's in and of itself probably ridiculous, but it's the landscape we have to live in. So dog is brought out to sniff this man's car. The dog is not trained to detect the odor of methamphetamine. The dog alerts, which means that either the guy had marijuana or heroin. That would be, I think, what the other two drugs this dog was trained on. And I may be not entirely correct on those, but dog was not trained to smell the substance that ultimately was found in the car. So they search based off a dog alert.
Find something else.
They find a drug that dog is not trained to detect. And their explanation that the Supreme Court takes as plausible is that the odor of marijuana from a dog's nose could linger for days or weeks after the substance has been there. So you handle marijuana and you get the oil on your car door, and now the dog can yip, 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 and you've got yourself a warrantless justification to search. That's a problem. This part of it, nothing is new. If we could get to full-bore legalization, we would maybe start to see a healing. But the way it sits now, the Fourth Amendment has been abused, ignored, disregarded, practically read out of the Constitution almost exclusively to advance the agenda of the war on drugs. That's what has hurt the Fourth Amendment the most.
Rewinding it a bit, even aside from the probable cause issue, even on a more basic level, the reasonable suspicion issue. I mean, how often do you encounter an officer saying, "I smell marijuana," transition the regular traffic stop for not using a signal to an investigation for possession of marijuana, and then they are able to maybe get incriminating statements or permission to search the vehicle, and they find something else unrelated to marijuana. We talk about this in this landscape of the Fourth Amendment. It's really hard to ignore. I guess like the elephant in the room. This is just the get out of jail free card, right?
It's the golden ticket for the police to be able to search because of the vehicle exception. I mean, It wouldn't be a big deal if there wasn't a vehicle exception to the warrant requirement, because then, all right, fine, you may have probable cause because of odor of marijuana. Go get a warrant,
right?
And let's let a magistrate decide whether or not, because the vehicle exception was crafted before cell phones, GPS, any of the modern police technology that's available, before even comprehensive, readily searchable license plate databases.
Right.
We decided that the inherent mobility of a vehicle justifies not abiding by the warrant requirement, even though some people live in their car. For some people, it is their house.
Right.
And all their personal effects are in their car. So, I mean, we could fix this other ways, but it seems to me the path we're on, given the case law and the way it's developed for the past 40, 50 years, would be to just legalize marijuana and take it out of the equation.
Yeah. Well, this is funny. Ready to get back to it?
Let's do it.
All right. Thanks, guys.
Appreciate it.